Good morning, everyone. We are going to go ahead and proceed with our next panel discussion so we can kind of keep on track and get to lunch in a little bit. So thank you for joining today. The topic we'll be covering in this forum is private security, corruption, and the case for transparency and regulation. We have an august group of thought leaders who are joining us today. I'll introduce them in just an instant. And want to prepare everyone that all four of our panelists have built a set of slides. They'd like to speak for about 10, perhaps a little bit more, 10 to 15 minutes on the slides that they have based on the lenses and the perspectives they are providing and bringing. And then after that, we'll open up for a discussion with the audience. So on this theme of corruption, we know that in many countries, the regulatory oversight of the private security sector is failing to keep pace with the rapidly growing and diversifying industry. It's leading to heightened global risks of fraud, corruption, and violence. When PSCs operate, and we heard Jamie saying this morning, in countries where there's weak governance or an absence of stable, steady rule of law, that often can provide fertile environment for corruption to thrive. Negative impacts can be multifaceted, ranging from exerting undue influence on the military and security policy to trafficking in arms or illicit materials. This panel today will examine the corruption risks that lie in the operations of PSCs and how these can be addressed through increased transparency and better regulation of the sector. So we're joined today by Ian Beers, who is the Performance Director at MSS Global. We're joined by Era Marcin-Neval, who leads global advocacy for Transparency International's Defense and Security Program. We are joined by Simon Maxwell, who is a solicitor with HFW's Global Complex Environments and Shipping Teams. And we're joined by Jules, finally, who is the CEO and chairman of SGA Security, who is, they are an ICoCA certified PSC company. So thank you all for joining us this morning and for leading us through this discussion. I think, Ara, you will begin, and thank you very much.
Thank you so much. I'm just want to start saying thank you for organizing and getting this panel in the agenda, in the program. We are very happy that we made it here. This is a crucial discussion. It's a critical conversation to have, especially with the companies. I represent, as Michelle said, the Defense and Security Program of Transparency International. As you might know, Transparency International is an anti-corruption civil society organization. We are a movement. We have presence in over 100 countries. And within the movement, I hosted by the UK chapter of Transparency International, but I have a global remit and a content-specific approach that is defense and security. Certain sectors require special approaches in the anti-corruption, as you will appreciate. It's really difficult to go for transparency in a sector that is dealing with security, defense and security issues. So that's why my organization and my program was created. We work across all the sectors, all the actors of defense and security sector. We work with governments, with ministers of foreign affairs and Ministry of Defense. We work with the militaries and military academies, so directly with the armed forces. We work with parliamentary defense committees. We work with other civil society organizations on anti-corruption, IHL, human rights. We work with UN peacekeeping in the European Union, NATO, and we also work with companies. So that's what makes our work quite specific and contextual, and our messages are adapted to the issues that we deal with. It's a privilege to be here. And I say it because we were just chatting, I have the best job of all, because as an NGO, I had the privilege of distance. So independent, I guess, pay less than, I guess, most of the people here. But my role is to highlight the risk, the threats that you are facing, the gaps in legislation, suggest recommended actions on how you can close the loopholes, and then that's your job to do it. So with that, I really appreciate the efforts that this community is doing for compliance and better governance of the sector. I always start with the definition of corruption, which is not a definition. We have some lawyers in the room. We don't have a definition of corruption. Often people use Transparency International definition of corruption. That is the abuse of an entrusted power for private gain. In a first glance, it's often seen as, in a narrow sense, as a financial crime, mostly about bribery and fraud, sometimes illicit financial flows. But corruption takes many different forms. It's much broader than that. And especially in the defense sector, that's very important to bear in mind. So it can be undue influence, and this is when private actors are influencing public policy or defense strategy. And we heard the panel talking about Wagner. Imagine the undue influence that a group like Wagner is exerting in the countries that they're operating in. Jobs and contracts being handed to friends and networks through nepotism. That's a corruption issue that you should be worried about. Elite capture of state institutions. Sextortion, something that military and security companies should also be very aware, and it's a form of corruption where sexual favors are currently the currency in exchange. So apart from being morally wrong, illegal in many cases, what corruption matters really in the defense and security sector? Corruption is dangerous in the sector. It has catastrophic implications. We're hearing today just saying, what is the impact in people's lives? It's also had catastrophic implications in national security. And it's a national and international security threat. Corruption disables defense forces from providing the public service that they are mandated to provide, the state and human security. Just want to put it there. I'm sure that you already talk about this, but let's use the Afghanistan case as the cautionary tale of this and the evidence for this point. Corruption is divisive in the defense sector. When the citizens grow unhappy and distrust the public armed forces, they look at non-state armed groups as a better solution. And it's wasteful. The amount of money that we spend, our governments spend in defense, when there's corruption on it, those budgets could have been used for a better end. And I use the example of Afghanistan, and I think colleagues today in the panel will talk more about Afghanistan, maybe about Ukraine. Mali is another example. My organization works quite intensively with years of corruption and neglect, including embezzlements and funds for suppliers, undermine the capacity of the armed forces and bolster insurgency. Why defense corruption is such a problem that is so tricky to tackle? And I'm not going to go in detail because you know, most likely will know this. It's the high value of the contracts, plus the secrecy of the sector, the political connections between private actors, the clients, the customers. And it's a niche expertise. There are not that many people, there are not that many of us around. So often governments rely on you, on military companies or arms companies to tell them about the threats and how to address those threats in most parts of the world, in most governments of the world. So this is the recipe for corruption, when there is a lot of money and little scrutiny, and only a small group of people who understand the issue fully. I want to talk about, I think I'm consuming already too much time, feel free to interrupt me, of the role of the private sector on all this, because it plays a critical role. The private sector plays a very important role in crisis and conflicts. Companies develop, produce, and trade weapons. They're supporting security services. And often is the private sector reach conflict or affect a fragile context. So you get often to places that others don't go, or they don't know how to operate. But there's some risk involved that we have seen in our research. Some private security companies or some private military and security companies, there's some inflating threat perceptions, also arms companies. So they're sitting at the decision-making table when the government is defining the defense strategy. And you've seen this, one big arms manufacturer is telling them, the threat is this, and you need this kind of weapon. I've seen this, I worked on arms control before, and I saw a country that I won't mention that didn't have access to the sea procuring a submarine. So it's serving as advisors is that undue influence. You can indicate conflict of interest, you can exert an excessive influence in the decisions. Some companies have access to valuable natural resources. Some companies make it a regular thing, and they said in the past that it was part of the business to pay bribes to government officials because that's how you secure contracts. Sometimes what the companies do, the private sector do, is to support private and local organizations that feed into sectarian and criminal violence. Sometimes you're enhancing capabilities of actors that they are corrupt or malign. And sometimes the companies directly engage in illicit economies, like arms trafficking. So we must also talk about the detrimental impact of corruption in your business. I think this is something that you will know better than me, how it distorts the markets, how drives up cost and creates an atmosphere of uncertainty. And when allegations of corruption hit a company, the fallout is quite severe, with lengthy investigations, draining the resources and eroding the shareholder trust. In the sector has done a lot to mitigate the risk within the industry, but yet corruption still finds its way into it. I think my co-panelists will talk about the procedures in place for the companies, and I know that many companies here are committed to adopt those adequate procedures, like collaboration, share knowledge, this collective action that we have here. This is an example of those procedures. But what I want to say today is that I want to ask you if those adequate procedures are truly enough to tackle corruption. They might be compliant with the law, But leaders must go, in the private sector, must go beyond mere compliance and question if what they have in place truly will stop corruption and distracts. And it's not only corruption in your companies or corruption in your country, it's corruption where you are going. Are you helping to exacerbate corruption? Are you contributing, exacerbating corruption? Very quickly, I invite you to go to our website and look at some of the products that we, research products that we have on companies and corruption. We have the Defense Companies Index on corporate transparency. This is mostly arms manufacturers, but the index is established standards of what you should have or consider if you want to minimize the risk of corruption. Someone was mentioning before, and I'm sure they will mention before, I think later today, Jamie, I think, was mentioning the importance of governance and attacking the issue through a holistic approach and mitigate the opportunity, minimize the opportunities of corruption to happen. So this index gives you the standards that you can follow. Dividing in risk categories, these are the most important, most serious categories, risk categories. So from leadership and organizational culture. So if you look at the right side, those are things that I like to say are external to your company. And the left side is things like policies in place internal to your company, how you treat your employees. Do they have a whistleblower protection? Do you have a way of doing the diligence about the conflict of interest? What culture you have in the organization. The right side is things that is more worrying. And as you can see, is also, this is a color map of the results, red being the worst, the most high-risk category. It's supply chain management is a huge risk category. And offsets in terms of arms manufacturers especially, agents and intermediaries. So, as I said, in our research, we are pointing out the gaps, and we made some recommendations. It's for you to address them, really. I want to stop here in the supply chain management because I think that's one risk category that I think is, these are some of the questions that we ask companies. Does the company require of all suppliers to have an adequate standards and anti-bribery? And I know we do this research with companies. We talk to the companies, we explore, we understand the limits. And often, the companies don't know the supply chain. It's very difficult when maybe you know tier 1 and tier 2, but then it's very difficult to understand at local level your suppliers and your coordinators. So some of the results that we have in the index are not great. 93% show no evidence of high-level ethics and data on suppliers. So we have a situation where headquarters and the main company have the stringent controls, a good culture, good leadership, good internal controls, good relationships, good investigations, but then it's partnering up with companies that have nothing of that. And this is, again, your power to improve the governance of the whole sector. Our index doesn't look at instances of corruption in companies. We are not interested in that. This is not, and this is one of the differences that we have with the rest of the transparency movement. We are looking at it as a systemic approach. What we are looking is what you need to do to change the whole sector, to improve the anti-corruption and the resilience to corruption in the sector. And for that, we're asking for corporate transparency. Because transparency, even if we understand that it's difficult, given the topics that the field that we work on, is the best tool if you want to tackle corruption. Also puts peer pressure on others, peer colleagues, companies, to give as much transparency, corporate transparency as possible, and engage in good governance of the whole sector. Because otherwise you're going to have some companies that are going to be doing the right thing, the ethical thing, and they're not going to be getting those big contracts because you know that there are the other companies working in the shadows. So unless the sector is together, we are not going to advance on this. And I'm going to stop because I think I consume most of my time, but I'm happy to answer questions. I will say corporate political engagement, beware of that in terms of recommendations. Put steps in place when you're working in high-risk areas. Understand who the host nation, where your operations are, and who are the players. You might end up partnering up with warlords and human rights abusers. Make enhanced procedures of assessment of mitigation of corruption risk, especially when you are operating in high-risk markets. The beneficial ownership, especially from also your supply partners in the supply chain. And as much as possible, more transparency also in your subsidiaries. We'll stop here. Thank you for your attention.
Thank you, Laura. I know we'll hold off on questions until after all four of the panelists have presented. So yes, please. Thank you, Jules.
Yes. A company's perspective. SGA is active in East Africa, Kenya, Uganda, and Tanzania. I would like to come back to what was said this morning. Somebody said private security is boring. If you really feel like that, and then I come and invite you, come over to East Africa. And I can assure you, it's the contrary. It's not boring at all. And there is something else from this morning's meeting that I also would like to rephrase or phrase. I think it was Professor Alexandro who said Wagner and the whole, let's say, illegal part of the business or the security industry, they try to create chaos, isn't it? Chaos. I would like to mitigate it a bit. What I see is quite often confusion. People have apparently a big interest to create confusion. I'm going to address this in the small slides. Let me see. The private security scene in Kenya, just, in a nutshell. 800,000 to 1 million people are active. I don't even want to say employed, because they are not employed, they are active. It's the largest private sector in Kenya when it comes to people's working, employment, and again, quote, unquote. We have a regulator that is active since 2022, and we've clearly stimulated that because to create rules, to create a framework, but it's a start. I mentioned there's now about 800 plus companies registered. Before the registration, there were some informal numbers, about 4,000 to 5,000 security companies. But again, there's now 800 that have a license. But still, 95% or even more, you mentioned 93%, so it must be true. But 95% is non-compliant still, even, you know, whether they have a license or not. So a challenge. What are the main issues that at least I want to address here as an example, and I think it's good to understand, is not paying minimum wages is a clear indicator, not paying taxes, and many other social and governance. The ESG, I'm referring now to the S and the G there. And what are the main reasons is obviously corruption, non-transparency, and there is an emerging developing market, and affordability is a very big issue. There's many parties actually that can't afford, well, I should not name brands, but the Mercedes, but they still, you know, they want a Rolls Royce, for instance, you know, and so anyway, that's causing quite some challenges. Puts the framework. I would like to zoom in a bit on the minimum wages and now the confusion. We looked into this, and the reason why we as a company started to look into it is because for quite many years we were subsidizing our guarding business in Kenya, subsidizing, making losses. And I felt we need to stop it, and we need to stop it dramatically. But how to do it? That's the journey I'm going to explain. Minimum wage, the first confusion started. There are 6 types of minimum wage today, or I should say maybe yesterday, because it's not clear now. Day and night guards we have, but there's different rates for city, municipality, and rural areas. And to give you the flavor, the rates in the city are twice as much as in the rural areas, and the municipalities are a bit in between. So most of the companies that are not, you know, they are not even paying that base salary, because we have a base salary. There is a mandatory housing allowance of 15% of that base salary. And in Kenya, we have shifts of 12 hours. Yes, you can debate about it, and if we have more time later on, we can, but that is the standard. But of that 12 hours, it means that 3.5 hours is, by law, is overtime. So basically, if you add it up, you have the base, and you add the 15% and the 43%, then that gives you the sum. To give you the flavor, today it's about $200. That is if you pay this in the cities. So basically, of those non-compliant parties, most of them don't pay even the base salary. It gives you the flavor. Even government. There was a recent tender for the central bank. You would expect they can afford, but they were not paying even half of what was required, and this is government. Who are the players, and what did we try to do about this? And we took indeed an initiative as a company to try to change. And first of all, try to understand what's going on actually and create this transparency. The major players to change was Ministry of Labor, the PSRA, the regulator, unions, and the employers. And it's amongst others, but KSIA was the major one that played a role. And we used actually that employers' organization to, you know, we started to frame the issue. And you would wonder why don't those parties, why do they have no interest to change this, to address this? So that was the question, was difficult to answer initially, and again, confusion. But we started to ask Ministry of Labor, could you give us a letter explaining what the minimum wage is, so that we can show to people this is the minimum wage? Interestingly enough, they couldn't or they didn't want to. Then we went to the PSRA and said, hey, you have given 800 licenses. But are you sure these companies are compliant when it comes to minimum wage? Yeah, well, Ministry of Labor has not indicated that they are not compliant. Well, so pointing at the other part. The unions, interesting. You would expect them to be very eager on this topic. Yeah? But they were not. And basically what I told them is that, but if 95% of the companies are not legally acting, do you think they are allowed to become member of the unions? That was an eye-opener. Yeah? Now they said, oh yeah, well, I said, maybe you have now a couple of thousand members, you should have a couple of 100,000 members. And you don't have them. So basically, they said, oh, well, yeah, maybe it becomes because of interest to do something about this. And then government employers, of course, even within the employers' organizations, you have the same challenge. Many of the companies are also not compliant. But, of course, now there is also a relation. I have said excluding customers for a reason. Even clients were abusing it. But if you have a license, if you have a license being given, then you must be compliant. So now the clients started to use it. Top clients, financial institutions, working from tier 1 to tier 3 companies, because they have a license. So everybody was actually pointing to each other and fooling themselves. And government, I made quite some bold statements in this respect. I said the security sector is bankrupt in a macro sense. And of course, that's how you get attention. And they asked, what do you mean? I said, what is the contribution to the economy of Kenya, of this sector? There's only a few parties that pay taxes. Well, we are amongst them, but I said, if you look at totally, how much does this bring to the economy in terms of taxes? Very little. So you have a sector, 800,000, 1 million people, and they don't bring anything. And what about security, by the way? If you don't pay your minimum wage, if you don't pay the basic salary, do you think you create a secure environment? No, you don't. Most important part, because that's what we're here for. So anyway, through these questions and through mainly the employers' organizations, we started to bring these parties together and try to create a mutual platform so that they work together. Well, the effects has been, first of all, the parties can't shy away anymore because the ghost is out of the bottle. People know, hey. The regulator recently has published the build-up of the minimum wage. They made a mistake, so they increased it with 12% from the cities, and they have now one rate. And obviously, this is Kenya, what happened? A lot of companies, stakeholders, they started court cases. Now, this one most likely won't take as long, but if you really go into individual court cases, I was told Court of Appeal has 10 years delays. So, but this one will be will have the focus and the attention. And most likely it will be sorted out. The good news is, I think it is transparent now. It's known, this is what it is. And if you're not paying in accordance, so if the contract, put the flavor in, 30,000 is let's say, this minimum. So if the contract, if you're engaging with a contract for 15,000, then you can't be compliant. Simple as that. Yeah? So anyway, PSRA is becoming active, and the law now says, which is also an important part, is that you don't. It's not only a criminal offence done by the security provider, but also by the client. So the client is also liable now. And now the next steps, obviously, are government to set the example. They have issued a notice. And of course, I don't expect now that in one day everything has changed and will change. It will take absolutely a lot of time. And for all the stakeholders and parties actually like ICoCA and all other NGOs and stakeholders to monitor and keep this space up to make clear it has to change, because at the end it's the enforcement. Kenya has all the rules. Internationally, you cannot think about it. The rules are there, but they're not enforced. One thing I didn't mention, also from a government perspective, most of those non-compliant companies, who are they? They're old military, they're old police officers, they're members of parliament, they're politicians. And not all of them, well, there are also good ones in between, don't get me wrong, but there is a mix of interest. So anyway, it's not that we as the private sector and as a company are sitting and waiting for things to change. I can't change corruption myself, all of it, but I can set the rules within our own company. One of the rules, actually, we don't deal a lot with government companies for that reason, because, you know, we want to be transparent about it. Anyway, I think I should leave it at this stage. Might be a lot of food for thought, I hope at least, because we are not unique in that sense. Kenya is not unique, but this is what's going on. I think it's good to understand this. Thank you.
Hi, my name is Simon Maxwell, and I'm a solicitor in HFW's complex environment and shipping teams. So what I intend to cover today is firstly a quick introduction to HFW, what it is we do and why it's relevant to bribery and corruption. Secondly, I'll cover, there'll be a bit of sort of doomsbringing, so I'll cover the criminal law consequences of bribery and corruption, and then I'll cover thirdly the civil law consequences of being involved in bribery and corruption. And then lastly, I'll have a look at some defences and practical considerations when having to deal with it. So my overall theme, my overall message is going to be there are serious consequences for individuals and companies who deal in corruption or don't have adequate procedures in place to prevent it from happening. But going to the theme of the talk today, the case for transparency and regulation, well-run companies with a genuine commitment to not be involved in bribery will find that the legislation and the courts take a pretty practical approach. Next slide. Do I just click it? Fine. So for those of you who haven't come across HFW before, we're an international law firm with around 600 lawyers spread across 20 offices globally. Aside from the offices on the map, we also have many associated offices and friendly law firms that we use in different jurisdictions to formulate our advice and add to our advice. So, wherever you're operating, the chances are we've advised clients in that jurisdiction before. We're particularly strong in litigation and dispute resolution, We've had, I think we've been the most frequent user of the UK's commercial court for around the last 8 years. The reason why that's relevant is because, we have good experience as a law firm of knowing how the law is applied at the sharp end. Within the complex environments team that I sit in, we represent clients who work in or crucially have exposure to complex environments. So, that's the private security firms. But it's also large corporations, extractive companies, governments, NGOs, and also we do lots of work with insurers who are also insuring people who have risks in those environments. In relation to bribery specifically, we're most often asked to advise on sort of a client's conduct. And we most commonly come across it when bribery emerges during the course of a larger incident or during the course of a larger crisis. So it could be a ship stranded in a war zone, and we're looking at ways of getting that ship out of that war zone, and it might emerge then. It could be during a kidnap and ransom incident, where the ransom has to move, the ransom monies have to move across borders and through high-risk jurisdictions, or it could be during an evacuation from a conflict zone. Bribery and corruption comes up during all these incidents. And often when it does emerge, there are perfectly lawful solutions to that problem, and I'll come to some of these later on. But I should emphatically stress that we're not in the business of helping companies evade regulations. We're an international law firm. We're trusted by regulated entities to stay within the law, so we have to be whiter than white. So when you come to us for advice, we'll sort of tell you, if it falls within the law or not, and if it does, you'll end up with an advice from us saying, we, HFW, see no legal impediment to your course of action. And then what that gives you, and we'll come to procedures later on, but what that gives you is, if we're wrong, if we as HFW got that opinion wrong, that then forms part of your defence. You can turn around and say, well, we got an advice, it said we were compliant, and you can then turn around and sue us. Happily, it doesn't happen. So our perspective of bribery and corruption is quite a practical one. I suppose we're not on the ground like Jules, but it's quite a practical one in terms of how the law is applied. We consider the facts and we analyse a proposed course of action. Okay. So most people are aware, in many jurisdictions, there are obviously criminal law consequences to being involved in bribery and corruption, particularly in regards to bribery specifically. That can involve lengthy prison sentences for individuals and companies, and also directors of those companies. So, for example, underneath the UK legislation, that can mean 10 years in prison. There you can also be subject to large fines. Again, in the UK, it's unlimited. I should say I'm going to obviously advise mostly on English law, UK law, just because it's what I tend to advise on. Yes. But I'll come to why that also can apply to other jurisdictions as well. When we're asked to advise on bribery, there may be sort of a complex web of different laws. So we consider legislation that has extraterritorial effect, such as our own law, the Bribery Act 2010, but also the US's Foreign Corrupt Practices Act, the FCPA. And those are laws where, if the right triggers are met, they can apply globally. The bribery doesn't have to happen in the US or in the UK. It has global impact. And then what we'll also do is look at local laws. And I mentioned law firms that we'll use. We have we have a network of law firms that we'll use who advise us on what the local legislation is. So in regards to the offences, and again, I'm just going to use the UK's Bribery Act 2010 just to draw an example. So there are 4 offences under the Act. The first is the offence of bribing. So that can be whether you're bribing a foreign official or whether you're bribing someone in a private company. People often think it just applies to, because other legislations, it is the case. People think it just applies to officials. Actually, under the Bribery Act, it does also apply to private companies. Section 2 is the offence of being bribed. Section 6 is the offence of bribing a foreign public official. And those 3 offences, so the first 3 on the screen there, Section 1, 2 and 6, the offence is the person has to be either a UK national or registered in the UK if it's a company, or have a close connection to the UK. And it's worth noting again, if it's a company involved, the directors of that company can end up being effectively prosecuted for it personally, including up prison sentences. The last offence, which is the one that's probably most relevant, I think, to people in this room who are considering it, is Section 7, which is the failure of commercial organisations to prevent bribery. And for this offence, this is slightly wider because it's much wider. The commercial organisation needs to just have a close connection to the United Kingdom. So this could capture, for example, a European company that has a branch office in the UK. It doesn't matter if the bribery that they're doing is in, say, South Asia, and there's no other connection to the UK. If they've got and there's other triggers that can meet it, but if they've got a branch office in the UK, that company can be prosecuted in the UK, despite there being no other connection. Sorry. Yeah, so the offence is very wide. There's guidance produced on this. It's easy to find online, and if you have time, it's very easy to read. I implore you to read it. Essentially, but boiling down that section 7, essentially, if someone bribes on behalf of your company and the company procures a benefit from it, then the offence is committed. So this can capture agents, this can capture JV partnerships in certain circumstances, and it's strict liability for that company. So, you might say this is unfair. We didn't know it was going on. It was our agent who was doing it. And there are certain protections in place for that company, which, again, I'll come to. And I think Ian's probably likely to cover as well. So, in summary, on the criminal aspects, individuals and organisations that engage in, allow, or even don't have adequate procedures in place to prevent bribery can face criminal convictions. Okay. Away from criminal law, there are some others, and arguably more potent consequences for companies engaging in bribery. So I won't really touch upon the wider moral consequences. Safe to say that obviously we've got the quotes on screen. Clearly, the incentivisation of poor behaviour creates a less fair and equal society. What I will cover is the consequences for a company or individual who are involved in bribing in the civil law or non-criminal consequences. So under English law, a contract is, as many of you know in this room, many contracts that take place in what we would call complex environments, but are often governed by English law, so this applies outside of the UK. Under English law, a contract procured by bribery is voidable, so it can be voided by the innocent party, so it can be made not to exist. I suppose more generally as a point of public policy, judges will generally look pretty unfavourably on a party where they're aware that bribery is involved. And there's an amazing recent case which happened in the English High Court, which some of you might be familiar with. It was a West African state successfully argued that a natural gas contract from 2010 was effectively a sham because it had been procured through extensive bribery of government officials. The court found that the arbitration award, which was linked to that original gas contract, I'm trying to simplify this, linked to that gas contract, had also been procured effectively through fraud. And so it was contrary to public policy to therefore enforce that arbitration award and to enforce the underlying 2010 contract. And the judge who presented was given lots of evidence of bribery, lots of evidence of general corruption and skullduggery all over the place. And he, I suppose, summarised the disdain in which corrupt individuals are viewed by the courts with the quote, driven by greed and prepared to use corruption, they gave no thought to what their enrichment would mean in terms of harm for others. So why am I telling you this? The result of that judgment was that the West African state no longer had to pay $11 billion to that private company. So the arbitration award, which had basically, I think at the time it was given, it was something like $6 billion, and with interest over the years until the High Court case, it ended up in $11 billion. The High Court effectively overturned an $11 billion award. So that judgment would have been noted by many of the sort of general counsels, I suppose, of who instruct private security. And I suppose the main lesson from that is, if at the heart of your dealings, at the beginning of your dealings, the contracts are procured by corruption and bribery, you can expect to be dealt with pretty harshly by certainly the UK courts. And this goes to the last 2 points on the screen, which actually I've turned this one point and forgot. Commercial and reputational considerations. So if you want to work consistently for blue chip regulated companies, you have to play by the rules, and there's going to be a world of trouble if you don't, if you end up in court. And those companies, many of whom we advise across all our different sectors, shipping, construction, commodities, etc., all say the same thing. We can't be exposed to reputational damage. We can't be seen to be condoning bribery and corruption. Okay. So my last slide. So I suppose the practical implications and defences. So I mentioned at the beginning there was a robust and common sense approach lies at the heart of bribery legislation, certainly in the UK. So well-run companies who have a genuine commitment to preventing bribery will find that there's practical protections in place. I've given all the doomsday scenario, you're liable for this, liable for that, but there are practical protections and defences available to good companies, and therefore they shouldn't fear further regulation and transparency. So what are these practical protections? And I'll go through them. Firstly, or some of them. Firstly, in regards to the corporate offence that I mentioned, the one of failing to prevent bribery, the company has a defence if it has adequate procedures in place to prevent bribery and those procedures are working. You know, we were doing everything fine. This is an isolated incident of bribery, and we've got these protections in place. We've got these procedures in place, sorry. And the law is not prescriptive of what those adequate procedures are. It doesn't tell, basically the law doesn't tell you exactly what to do. It doesn't say you should fill in this Excel document, you should do this survey, you should do this. Instead, it's on the companies really and on other bodies, and again, Ian, from the MSS point of view, will talk to it. It's for them to look at their risks and to look at the risk of bribery they're exposed to. The risk of a private security company operating, again, in a complex environment is going to be very, very different from a cake shop in Walthamstow, you know. So the approach they have to take towards bribery should be tailored towards the risk that they're exposed to. And the reason why it's fluid is to sort of encourage companies to take practical steps to preventing bribery. The second, I suppose, protection in place, moving on to hospitality, always a slightly, sore subject, or people sometimes don't know what ground they stand on in terms of corporate hospitality. Always worry for business. As long as it's reasonable and proportionate to your industry and you're not expecting anything in return, then corporate hospitality, normal business practices are acceptable. And it's an acknowledged part of doing business under UK law, and actually I think in most other jurisdictions, but I can talk to English law. So the example is, say you have a client who mentions that he likes football, and you say, funnily enough, our company has debenture seats at Chelsea, and we take clients there all the time. Would you like to come along and watch a football game with us? And you're using it as an opportunity just to get to know the client better. It's just part of normal business. That's clearly fine. However, if that client mentions he likes football, and you then fly into Brazil, you put them up at a 5-star hotel, why don't you bring the wife and kids? Oh, by the way, I'm not coming, but you enjoy. Clearly, that's a bribe. And the reason why I've got the shades of grey on the screen, those are two clear positions, what is bribery and what isn't bribery. And there's shades of grey in between. And again, it depends on your industry and on normal business practices. And I think a good way that it got described to me is if your competitors found out that you were doing that, would they consider it to be a bribe? And if they would, if you look at it and go, well, if I found out my competitor was doing that, I'd say that's a bribe. You've probably time to rethink that approach to hospitality. Moving on, there are, and I think this is my final point, there are a number of protections in place for companies when they face difficult dilemmas, and I went through some of those at the beginning, and the payment of money is the only way out of that dilemma. So to use a case study, we had a recent case, which I'm going to anonymise, where one of our client ships was seized by a foreign navy, and that navy was not controlled by the government effectively. They were essentially acting as a militia, as the de facto power in that region. And the seafarers, the captain, and I think there was some private security guys as well, were thrown into a pretty miserable jail, in which there was definitely a threat of violence against them, and possibly death. So our client was asked to pay an amount of money, effectively a ransom, to have the people's release. Now, is that ransom then a bribe? Is it going to a government official? And we were asked to advise on those questions. And we were able to, and it's not an easy one, and there's no yes or no, but in this scenario, we were able to advise that on balance, the payment could go ahead for 4 main grounds, which I'll cover briefly. So the Navy in question were acting as a de facto power, so outside the control of the government. So they were effectively they weren't acting as a foreign public official, more as a militia. So we questioned, and it's not a cement answer, but we questioned, would that then fall under the Foreign Public Official Section 6 of the Bribery Act, and whether then that section was relevant. Secondly, we looked at the public policy, and the public policy driver of the 2010 Bribery Act was to prevent individuals or companies from gaining commercial competitive advantage. But that wasn't what was happening here. The money was being paid in order to secure the release of seafarers, not in order to beat the competition. So we sort of, again, we questioned whether it would fall under, whether it didn't fall within the sort of the spirit of the Bribery Act. Thirdly, duress. And I think there's a quote on the screen about duress. Good. The payment was being made against the company's will. It wasn't voluntary. It was being forced upon them by necessity. So again, the guidance. This isn't in the Act itself. That quote on the screen is from the official guidance. So duress can be used in certain circumstances. And lastly, human rights. There was a direct threat to the crew's human rights, the right to life and liberty. And we know from having done lots and lots of detention cases across the world, piracy detention, government official detention, where governments detain people wrongly. We know in these cases that, excuse me, they often go hand in hand with degrading and inhumane treatment, and they can have a profounding and life-changing impact upon many of the victims, both physically and mentally. So in such circumstances, we thought it was appropriate that the human rights legislation effectively trumped the Bribery Act. And in fact, on that, many of the, obviously, human rights are a key concern for all involved here. But that right to life and liberty will even trump other human rights in certain circumstances. So, for example, we've had piracy cases where we've had worldwide super injunctions granted, effectively stopping the press from freedom of expression, printing certain information, because what they might have done is print information about the wealth of the hostages. And to our mind, if that had gone to print and it had been known to the pirates, it would have potentially prolonged the detention of the detainees, of the hostages, and therefore their right to liberty and life. So it's a very powerful right. Sorry, a slight side bit there. So in summary, we were able to advise, on balance, we saw no legal impediment to paying the release of the crew, and happily they were released. I should mention, just for completeness, that might have been a different conversation had it been a terrorist group involved, but that's a can of worms for another forum, perhaps. Yeah. So in summary, in terms of sort of, I suppose, my overall theme, when dealing with bribery, you have to closely consider the laws which can have extraterritorial effects. It's not just the place you're operating in. The consequences when bribery and corruption emerges, you have to consider those. But however, companies, and again, go to Jules' presentation, I was very impressed with the steps that you've made as a company. Companies are well placed if they have a genuine commitment to preventing bribery, and they follow that commitment through with the correct procedures and a common sense and practical approach to preventing it. Thank you.
Good afternoon, everybody. I've been busily adjusting my presentation as we've been going through these other fantastic panelists, because they've been showing some real perspectives, which I think this should hopefully wrap and encompass that. So, Ara, thank you very much. That was, the good governance and the sectoral perspective. I will endeavour not to repeat anything there. Jules, really useful with that. The thing I got there was the competitive market and the dilemmas you're dealing with in that operational context. And Simon, the legal context, which is completely surrounding everybody. So with that, hopefully I'll be able to bring into this what we can actually do about corruption. I've got this image here because everybody in the room is from different parts of the world, and it's a challenge that everybody faces. And I think Simon mentioned it. It's often, I prefer to say, dilemmas that are faced. Not a challenge or a problem people might think is easy to surmount, but often it's not that clear cut, and it is a dilemma to be worked out. So the other part of that slide is we need to deal with it as a collective. Collective action is probably one of the most important methods of which we can actually deal with anything of this nature. But to enhance on Simon's piece here, to give a broad brush illustration of the different laws that we've got around the world, I've just got a sample here. And this is illustrated purposes. Pretty much every law, every country has the laws in place to deal with corruption and bribery. What I don't have is possibly a row at the bottom here that shows how effectively they are enforced. Some definitely have more teeth than others. Some are potentially ignored. But they all have the capacity to be extraterritorial. And a lot of organizations here might think that they're not an international company. Well, if you're working in your region and you're dealing with international clients, or you're being paid in US dollars, or your company has directors that are from a third country, you're an international company, and potentially one or more of these laws really does apply to your activity. So as an international or multinational company, how do you deal with this huge array of laws you have to do? First of all, the laws are constantly changing. The legal landscape is very much alive. This year alone, the US Department of Justice in March tightened up or updated its rule on evaluating compliance programs. And 2 months ago, on the 4th of October, the Department of Justice put out its policy on mergers and acquisitions and safe harbor policy. Now, what that means is, after a company has done an acquisition, it's got a period of time, I believe it's currently 6 months, where if it identifies foul play, bribery, corruption, whatever it may be, in that period of time, the acquiring company doing the purchasing can actually be given considerable leniency, a safe harbor. They literally use the term safe harbor. The company being acquired, the target company, many of you might be involved with companies that you hope one day to be acquired, are actually in a position of risk there, as the leniency will only be extended to the company being acquired if they are fully compliant with any investigation. So I'd put that there just to say that was 2 months ago. The legal framework is constantly shifting, and not to use a term that sounds wrong, but the net is drawing in. So to negotiate this international framework of issues, coming from a standards perspective, what we've got here is international standards. They are best practice instruments that have been put together by panels of experts, and there might be people on here, in this room here, that have been part of a committee for a particular standard, and it's the same with ISO 37001. That's best practice management systems to prevent bribery. It is individual law irrelevant, because it actually looks at the intended outcomes of a system that looks at the fundamental principles of what can happen and how to prevent it. So it's very useful for an organization that's got to negotiate multiple jurisdictions, multiple laws, and respect them all. I'm going to quickly move on to the sort of main thrust of my presentation here. That's collective action. And starting by looking at a case study of what we hope very shortly will be the reconstruction of Ukraine. It has been mooted as being the world's largest economic project since World War II, since the Marshall Plan. And looking at figures that have ranged from $411 billion to speculation that the reconstruction could lead to, could reach to $1 trillion. Now, and those estimations have come from the World Bank. We've estimated the cost of reconstruction could be $500 billion to $750 billion to rebuild Ukraine over the next decade. Security will be required, without a doubt, in almost all aspects of this enabling process. However, and I'm sorry to have to bring this up, but Ukraine faces another challenge, and that is corruption. It is the second most corrupt country, according to Transparency International's Corruption Perception Index, the second most corrupt country in Europe. So we've got a combination of extraordinarily lucrative opportunity combined with endemic corruption, which I already know from following Ukrainian news. They're taking great strides to prevent that. So ISO 37001, it's an international standard, best practice, put together by experts. It's reviewed every 5 years. So as the world changes, and it does, then the standards can be updated and take in the new context of a very evolving world. So the pivotal role that this standard could play is the requirement of organizations getting themselves certified to this in order to give assurance to their partners. what it could potentially have prevented, and it was mentioned earlier, is all the issues that blighted the reconstruction in the past 20 years of Iraq and Afghanistan. There's a lot of lessons to be learnt from that. In Iraq, there are cases where financial risk management, egregious overcharging, and fraud. A lot of corruption, a lot of bribery can be also labelled with other terms, fraud being a very common one. These reports often highlight the need for oversight in these projects. Afghanistan, it faced issues of like ghost soldiers who created by corrupt officials who diverted resources away from genuine needs and took the money. So the International Code of Conduct Association, 10 years old today, is a collective action organisation. People got together to sign the Code of Conduct and then actually do something about it. There's other opportunities emerging. The Ukraine Business Compact was raised this year, and, well, you can see there. It is a compact for leading businesses, international businesses, to sign and pledge that they're going to be doing business in a manner which is going to be enhancing Ukraine's recovery. And the parallels with the International Code of Conduct should be quite stark, really. So it's a multilateral initiative, and it's pledged to help Ukraine emerge from war more prosperous and strong. It contains some core principles, and I've circled the one down here. Implementing best practice corporate governance and working to identify areas where signatories and Ukrainian businesses can share capability and promote best practice in a mutually beneficial way. There are concrete endeavours aligned with the responsible organisations. So if you're an organisation that cares about corporate governance and also ESG, the G of ESG is partly what you're folding into there. And the societal benefit is all there in the S part. So what does impact of a good reconstruction project look like that hasn't been blighted by corruption? It should be the taxpayers of contributing nations having their money well spent, Ukrainian people getting the infrastructure they deserve, bridges that last, dams that hold, and power grids that see them into a prosperous, greener future. As I mentioned, the International Code of Conduct for Private Security Providers is an example and serves as a testament to the power and effectiveness of collective action. When organisations come together to uphold shared standards like ISO 18778 and ASIS PSC 1, they create a ripple effect that elevates industry practices. Such standards provide clear guidelines, and as they have been for the code, they are foundational in ensuring that companies not only commit to ethical practices on paper with signatures, but also implement them in their operations. It illustrates how industry standards can catalyse a shift from mere signatories to tangible, impactful change, setting a precedent for other sectors to follow. ISO 37001 contains a full guidance on how to put together, if you've not already got so, or to map yours to it, an anti-bribery management system. Amongst the title page here, you've got anti-bribery policy. For a lot of organisations, they think that is the beginning and end of an anti-bribery system. It's not. It's just the headline statement to give people an understanding of the direction. It's a far richer tool with training, risk assessments, communication, and monitoring systems to make sure that the system is operating and it iteratively improves and produces the results, the intended outcomes that's expected. Okay, mentioned about the evaluation of corporate compliance programs. March this year, you can find it on the internet. The US Department of Justice's criteria for evaluating corporate compliance programs. So in addition to ISO standards, there's a lot of other good, useful information out there that you can use, and it's well written and useful to even the smallest of companies. I actually have here the guidance to the UK Bribery Act, which has got fantastic case studies that take it down to a real practical level. As we've been done in the past, MS Global often maps different human rights instruments against the standards it deals with, and we're always in the process of doing that. So some countries, their law will say you must have, or a legal requirement to prevent bribery. Others will just actually not so much mandate it as encourage it. The page here is from the FCPA guidance document, and I can let you read that yourself. So it will give meaningful credit. It will look upon an organisation that's got a genuine anti-bribery system in place, not just a policy and with a flourishing signature attached to it, but a genuine system in place to prevent bribery. As Simon mentioned, if an isolated occurrence does happen, then this can assist in the defence of that organisation. Now, you might look at this and say, well, how's an isolated event going to happen? It might be not necessarily your organisation, but your supply chain. And it's the supply chain that really is quite important here, because you've got customers. You will have clients that rely on you to provide them a secure environment. They are under the same pressures, same legal constraints as you are, and have to abide by the same laws. The supply chain, you are a supplier in that. They see potentially you as a risk. Would a dilemma where you are required to pay a bribe to maintain or obtain a operating license actually be something which your customer is inadvertently complicit with to a degree? So your clients, your customers, your future intended customers, international organizations or local organizations, again, with good governance, will potentially value your ability to have your systems in place to prevent bribery. They might actually appreciate that system being accredited by a third party. All of this adds to the defence or increases the logic that you've done everything you can. And I think the important thing is it's not about putting up an image that you've put in a defence, it's actually having a defence in place to prevent it from occurring in the first place. So, as I've already alluded to, well, I'm not necessarily alluded to, what we've potentially got is grand corruption, where organisations feel the need to buy a contract, and Simon mentioned how that can undermine the entire contract that's written, or organisations can suffer from petty bribery. Now, if you're an organisation that is lucky enough not to be involved in the world of grand corruption, but petty bribery is a pernicious issue, which, if not dealt with, can actually blight the whole of society. You might be happy to pay a facilitation fee to get through a checkpoint, but the community, the locals, they will be having to pay probably a facilitation fee to see their local medical doctor. So it is a collective action issue. We all need to do our part. And in this particular collective action, it's not just security companies, but it's also the customers and clients of security companies that all need to make that first step. So, in conclusion, what if it's just me, my company, that takes these steps to avoid corruption, to prevent bribery? You know, will it be my company that gets left behind? Does playing fair mean being at a disadvantage? Let's acknowledge that effectively combating bribery extends beyond mere declarations. It necessitates tangible actions. This is exemplified by the International Code of Conduct that we've already been part of. Similarly, the adoption of standards like ISO 37001 could be critical in creating that fair play. And in the example of the Ukraine Global Compact, could be the thing which actually gives it the teeth it needs to move from mere declarations to something a bit more solid. So while we can choose to ignore these issues, the reality is starkly different. The US Department of Justice's new mergers acquisition enforcement policy announced this year underscores the global trend towards heightened accountability. The net is closing. Without collective commitment to unified standards, the risk of unethical practice in pursuit of lucrative contracts remains high. By collectively committing to rigorous best practices to ensure fairness, transparency and integrity, in so doing, we'll avert a race to the bottom, which a lot suffer from. Thank you very much.
Oh, is this on? Yeah. I know we're short on time, and we probably have some audience questions. So there's just kind of one thing I want to ask to all of you, especially because I know Jules and we do the same kind of work, and so your presentation was very compelling to me, and it was chilling in some ways. So, you know, we've talked a lot about issues of the laws and what enforcement can look like, but we know that laws, if they're not put into effect, they are something that hamstrings or is just ignored. So for the three of you, I wanted to ask in particular, we've gone over the ways that corruption infiltrates business practices, but for a company like SGA and for the case study that kind of showed us in Kenya, what is an ethical company supposed to do to maintain competitiveness when competitors are either non-compliant or flat out corrupt? What guidance would you give?
Well, it is a dilemma, and for me, it's a collective action problem. And getting a group of like-minded companies together and ethical customers, the ones that can be the leaders in their sector, and having them demand standards. And it should be noted that the International Code of Conduct itself does contain anti-bribery or anti-corruption provisions. So all those organizations should be agreeing to identify and contract with the ethical security providers. But collective action is probably going to be my main theme on that. I don't know if anyone else has got anything.
Thank you.
Yeah, I agree with what Ian said. The only thing I'd add in terms of competitiveness, I appreciate it's easy for me, sat in an office in London, to say what you should, and this is why people get annoyed with lawyers, and they're right to. In an ideal world, you should obviously follow the correct guidance and laws and all the rest of it. And obviously, I'm not going to say anything apart from that. The only bit I'd add is what you should be doing is what you're doing now, which is screaming from the rooftops. We are compliant. We are doing this. We are part of ICoCA. We do take this seriously. We're actually actively going out and trying to change legislation. And in terms of competitiveness, yes, that might end up. I don't know your commercial arrangements. That might end up with losing some money in the short term. But actually, when you're trying to get business off, going back to my point about blue chip companies. In the future, and hopefully now, when you're trying to get business off those larger companies, it's easier to do if you've been doing that screaming from the rooftops. So, that's all I'd add to that.
Thank you, sir.
Really nice. I don't know if I can add a perspective. Corruption is often an afterthought. So we see it with governments, we see it with companies, and we see it in military operations. So it's not that you don't see it, it's that you just look to the other side. Because either you think that it's complex, we were talking before, or because you think that it's part of the system. So that's why my organization works with all the actors, because we need to break the system. Corruption needs to be considered as a threat to security. It needs to be considered as a threat to your productivity and your gains. Because what often happens with any of the actors that I mentioned is that you secure the space, you secure the contract, and then corruption comes back, especially in the sector, in the defense and security sector. So we are next week in Atlanta, putting a submission and calling in the Conference of the State Parties of the Convention Against Corruption, calling for international community to start thinking as a corruption as a security threat and saying no trades off, because you're going to trade and you're going to get that contract and you're going to secure that country. You're saying, okay, this is a warlord, I will deal with him, I will worry about that tomorrow in Ukraine. But then it will come back to you with negative consequences for all those actors and more instability and more insecurity. So no trades off, I would say.
Thank you. Thank you all. So I know we have lunch next, but maybe 2 or 3 questions from the audience if there's time. Yes, sir.
Thank you. Thank you so much for the presentation. Really impressive. My name is Hassan. I'm the president of Iraqi Human Rights Defenders and Activists Consortium based in Iraq, Baghdad. So let's, well, the corruption is a real serious issue in Iraq, and we are one of the top countries in terms of the rates of corruption in Iraq. But let's look at the corruption and private security companies from different angles. And let me give you this example. So many, and the majority of private security companies, especially the foreigners, they are not getting involved directly with corruption. So they are having those contracts with law offices. So they have the contract with law offices, and those law offices paying huge bribe to escalate and just to speed up the process of registration and to get the to accredit the operation license. And that should be with the Minister of Interior and with the Ministry of Trade. So to register as a company and then to get the license from the Ministry of Interior, the Private Security Companies Department. And in this scenario, we had this debate with private security companies as civil society organizations, and they told that, no, we are not involved, it's the company. And they are aware, because so many of them, they are aware that the high fees, including the high bribe they are paying to the government in order to register. Otherwise, they will stuck in the routine process. They will, fall into the system and delay, and they will their license may be suspended. So they have to. But we are really confused, how to address this issue, how to intervene as an ICoCA members and as a civil society activist. The companies, how we can impose the regulations on the companies while they are aware that their contractors, the law offices who they are contracting, they are paying a bribe. They are aware, and if not, they know somehow, and we are telling them that those offices are really paying a bribe. And that's why they are charging really quite high sums of money just for renewal and registration, etc. Thank you so much.
Yes. Thank you. And we've seen that a lot of the growth in the private security services membership in ICoCA has been driven by new Iraq security services companies. Guidance for his comments and his concerns?
It goes back to an entire shift in the operating environment. It's not just the security companies. I said security companies and customers. We've got intermediaries, and using law offices as their agent to do work on their behalf. That's an aspect where their supply chain is acting corruptly for their benefit. And they need systems in place because they're basically chancing it until they eventually it gets identified. How to deal with it? Well, organizations that are content to do that, they don't have a anti-bribery management system in place. Or if they do have one, it's duplicitous. To think how they could actually negotiate the issues that they're probably having, because it could be getting together as a collective and campaigning to the Ministry of Interior if there's some hurdle that they are having to surmount through this workaround. then maybe they need to get together. It sounds easier said than done, obviously. Get together, and again, I go back to collective action and campaigning to the correct ministries of why they're having to do this and how it needs to be remedied at the root cause. I don't know if Simon?
Yeah, I haven't got much to add to Ian's really, but obviously, again, going back to my presentation, under English law, that would, well, without knowing the facts, that looks like an agent relationship, and there's a deal of control going on, and it's a way of getting around that. So, under English law, that would fall foul of the legislation. Now, the companies that you're discussing may not care about English law. It may not affect them at all because they operate in Iraq, and it has no impact on them. So, really, I would just echo Ian's point, which is that is like it's not a localized Iraqi issue, but that's an issue which needs political lobbying and needs collective action. From a layman's point of view on those issues, it seems like that needs to be done at a certain level, and it's involving organisations and as much collective weight as you can get behind it. If it's a substantial problem and it's I mean, not predicting what you're going to say, but it harms the community around them if practice of that goes on. So it has to be, I suppose, nipped in the bud. Yeah.
Thank you so much. So now I can say something else. It's a problem. There is a wicked problem, and we need all the actors to be committed to solve it. So, like, companies only won't solve it. And you need the governments, you need the foreign governments, you need civil society, so you need everyone. And that's why I'm so pleased to be here today. I will say, you brought the case of Iraq being a company in Iraq. But for security companies that they are intervening or working in high-risk markets and in complex environments, we have an index that is now the Corruption Perception Index that is looking at government defense integrity. So is when you are coming to a new market that you're not too sure, check that index and it will help you to assess your risk and put some mitigating measures ahead of coming to that. It's very detailed and it's going to tell you what the corruption vulnerabilities are. So like the issues with procurement, there is even now we're adding indicators on gender. So that can help you assessing the risk, corruption risk coming into the markets.
Thank you.
Yeah, just another point to it, because it seems some of the challenges are similar. And indeed, as a company, you can't do anything about that as such, and I can even imagine, like in some of our jurisdictions, you can't even shout it from the roof, actually, because it will have potentially repercussions. But that's where the political angle absolutely should help. And there is another aspect, I think, also, which is important, which I would like to repeat. It's also the client's perspective. If clients, are just leaning on the fact that you have a local license, we all know in those countries that a local license is not the right criteria to decide whether a good service is provided or whether somebody is, for instance, applying the human rights. So I think that assessment is important, and that's why, for instance, ICoCA is very important. Now, we started 5 years ago because of these issues, the certification of ISO 18788, because that gave us a quite leverage, to distinguish with other companies, but also internally help our people. We employ 20,000 people in the region. So how do you mobilize them? They come from a culture where this is all common practice. So how do you mobilize them? How do you give them a perspective that things should change? And I think that is very helpful. But what I'm really missing is besides, you know, all the political angles, but it's the client's engagement. Really, we often, and we do shout it from the roof to our clients, don't worry, we do that. And I meet with, you know, with the executives, because even if you meet at the middle management, they have already their own views and their own practices, actually. Sometimes they are, or quite often, they are part of the system. So you have to engage with the top management and address things like ESG, ICoCA, certification, etc., because that's the only way. But then, notwithstanding this, as I mentioned in my presentation, we see in quite some sectors that even the financial sector, I would say, that is one of the first sectors that could afford, you know, to pay for quality services. And they are the cheapest ones. You know, they are really hiding behind, yeah, but okay, but you have a license, so you are compliant. And they know it's not. So I think that is one of the things, and that's why after this ISO 18788 process, we became a member of ICoCA to have an organization and to engage with all stakeholders, because you can't do that on your own. And I think that is, well, key to bring everybody together on this.
Thank you. Well said, and a great argument, a great case for the importance of this association. So I know that it is well into lunch at this point by about 15 minutes. So if no one else is holding a microphone, we'll go ahead and end this session. I want to thank you all so much for your engagement and your thought leadership on these very critical issues. Thank you very much.